Good morning. You ready to proceed? Yeah, may proceed.
I believe we're again here in camera matters, and the state would call Mark Tinsley to the stand.
Raise your right hand, left hand on the Bible. Do you affirm the testimony about to record in this trial shall be the truth? So help you God.
I do.
Take a seat in the witness stand. State your name again for the records. Spell your last name.
Morning, Your Honor. My name is Mark Tinsley.
Mr. Tinsley, how you doing today?
Good.
Very quickly, you understand, obviously you're a lawyer, you understand we're here for some in-camera proceedings, so we're not going to go into every bit of background and detail that we would were you testifying before the jury. You understand that?
I do.
I do want to, though, kind of move through quickly some of the subject matter that the state proposes to put before the jury. But very quickly, if you would, just quickly tell us what you do for a living and what kind of practice that you have.
My name is Mark Tinsley. I practice law in Allendale. I have a fairly statewide practice, primarily personal injury, plaintiff's work.
All right. And how long have you been practicing in Allendale?
Since 2000, so 22, 23 years.
Do you have a statewide practice, or is it primarily?
To the extent I want it statewide. I mean, I handle cases statewide if I'm inclined to handle those.
Okay. Primarily focused in the 14th Circuit, is that fair?
14th and the 1st.
And the 1st? Okay. You know the defendant, Alex Murdaugh?
I do.
And how did you get to know him?
He practiced law in the adjoining county. I had a number of cases with his firm, small bars in the two counties, and known him since shortly after I came to Allendale.
And do you know other lawyers in the what used to be known as PMPED firm?
All of them.
And are those individuals that you may have had cases with, or just generally in the same line of work with over the years?
Yes.
I want to take you to February 19, and are you familiar with the boat case?
Unfortunately.
Okay. And do you represent the Beach family in the lawsuit related to the death of Miss Mallory Beach?
I do.
And ultimately, you ended up accepting that representation and filing suit against a number of defendants, including the criminal defendant here, Alex Murdaugh. Is that correct? Okay. Tell the court just very quickly who the defendants that you sued, at least initially, when this case started.
Mr. Waters, my recollection is that I sued Alex Murdaugh. I know I sued Luther's, which is a bar downtown in Beaufort. I sued the Woods, which was where the kids had gone for an oyster roast. I sued the Murdaugh Family Trust, which owned the property where the boat was launched from, and we believed that there could have been some drinking that went on there. I'm not 100% certain in the first lawsuit if I sued Buster Murdaugh, which is Alex's son. But I think those were the defendants initially.
Okay.
And maybe Randolph Murdaugh personally as well.
Not long after you started the boat case, well, let me ask you this. Did your client, Renee Beach, have any particular experience at the scene that informed how you were handling this particular case as you went forward?
She certainly had an experience that prompted the call to me.
Okay. Now, can you explain that to the court, please?
She wanted to go down to the bridge where the boat crash had occurred. I think this was either Monday or Tuesday, so the crash happens early Sunday morning. The scene's cordoned off, and she's told she can't go down there. And just a few minutes later, Alex's father and his wife pull up in a car, and they're waved under the tape, and they go down to the bridge. And she she was very upset by that.
Okay. And did she, in your discussions with her, did she give you any particular instructions about proceeding forward in this particular case, as part and based on that experience?
No. Nobody really gives me instructions.
I understand. All right. Not long after you get involved in this case, did you have any chance to review and look at any insurance coverages that may be available to the defendant?
Sure. My recollection is within a week, certainly 2-week kind of time frame after the boat crash, Danny Henderson, who was handling the boat crash as Alex's personal lawyer, brought me all of Alex's insurance policies, and so I reviewed them at that time before I filed the lawsuit.
And what was the purpose of you reviewing those policies?
In a civil case, the only thing that we can do to try to, under the law, make a party whole is recover money damages. And oftentimes when we are drafting lawsuits, we will try to draft the initial lawsuit to make sure that there's insurance coverage. So that was the reason I wanted the coverage. And beyond that, sometimes, like I did with some of the initial defendants, you can, because of the circumstances, because of the culpability, how bad the liability is, how catastrophic the loss is, many times insurance companies can be leveraged to pay their insurance out to get these people closure. No amount of money is going to make them whole. So the best that we can do is try to get them some closure and help them heal.
All right. And when did you determine, as you looked at what coverages were available to Alec that potentially could be relevant to the boat crash?
Well, so there was $500,000 that Progressive had on the boat. It was a watercraft policy. Although I've never seen the policy, that insurance was offered almost immediately to all of the victims, not just the Beach family. There were 2 other girls on the boat and 2 other boys, and including Paul Murdaugh. And so when I reviewed the policies, it was apparent to me that there was no possibility that any of the insurance that he had at the time of the boat crash would apply to this. And if there was a possibility, it would be limited to an idea that Alec was negligent in allowing Buster to give Paul his duplicate ID that he had made so Paul could purchase alcohol.
Did Alec have a policy, an umbrella policy with Nautilus at this point in time that was available?
He did not. He had...
And explain that to the court, why that was not available, please.
It appeared from review of the records that there was an open claim when the policy came up for renewal, and that open claim was the Satterfield matter. And that it was Nautilus and I think Lloyd's of London, and they would not renew the policy. And so he had to then seek other coverage, and what he ended up was with Philadelphia, and it was a commercial hunting operation policy that contained very broad watercraft exclusions. So they even barred a negligent entrustment claim as it related to a watercraft.
And that Philadelphia policy depended on Moselle being considered as a commercial hunting lodge, is that correct?
Not only Moselle, but the occurrence, in other words, whatever it is that causes there to be coverage, had to arise out of a commercial operation, as I read the policy.
Realizing that as it related to Alec, specifically, was he essentially underinsured as it related to what the recovery you were seeking in this particular case?
Oh, absolutely.
Right. And what was your ultimate goal, though, in seeking recovery as it related to Alec in this case?
Well, it changed over time. And I mean, initially, I believed that the case would settle. I didn't see how people could ignore the significance of the loss, the public support of the community for the Beach family, and then the hue and cry as it related to the liability and the Murdaughs in particular. And so, you know, it changes over time, but the one consistency was to get the case resolved.
Okay. And did you make it clear to Alex attorneys that you were seeking a personal recovery that he would have to pay as opposed to just accessing when insurance coverage was available?
Always.
And that was consistent all the way through, is that correct?
All the way through.
Were you making substantial demands to the defense that Alec pay a substantial recovery personally?
I think by most standards, and I don't want to seem crass when I say this, but the Beach family stood on the causeway for 8 days while their daughter's body was in the water. I don't know that there's any amount of money that somebody would willingly take to go through what they've gone through. But if you were asking a lawyer who does civil work, was I making a substantial demand in terms of a settlement? I think that most people would say yes.
In your assessment, did that come as a bit of or did the defense express to you surprise that you were seeking a personal recovery from Alec rather than just simply trying to access what insurance coverage he had?
Yeah, some people did. John Tiller was primarily handling the case for Alec, and I didn't get that from John, but I got it from a lot of people.
In August of 2019, is there a particular conference that those in your line of work go to?
It used to be called the Trial Lawyers Conference, but yeah, it's in Hilton Head, and I went in 2019 of August.
Did you see the defendant there?
I did.
And did you have a conversation with him about the boat case?
I did.
All right. Can you relate that conversation to the court, please?
Yeah. I think, I'm not 100% certain that it was a fundraiser either for Mr. Harpootlian or it was a fundraiser for Lindsey Graham. As you come into the hotel, there's a gathering area. It's in the evening before everyone goes to dinner, or it's immediately after. I'm not 100% certain. But the room's full of lawyers, and Alex sees me, and he comes across, and he gets up close in my face and says, "Hey, Bo, what's this I'm hearing about what you're saying? I thought we were friends." And I replied, "Alec, we are friends. If you don't think I can burn your house down and that I'm not doing everything and I'm not going to do everything, you're wrong. You need to settle this case." Okay.
And so what was the point of that conversation? What was, if you can explain to the court what y'all were talking about, what is Alec upset to as you understood it?
That he was going to have to pay was what he was hearing. That's what it was. That's what the point of it was. We're friends. I took it as he tried to intimidate me. He didn't intimidate me, and sort of bully me into backing off.
Was there a mediation in September of 2019?
There was. No, 20. September of 20.
20. Before we get there, we move into early March of 2020, and we probably all know the answer to this, but what happened in March of 2020 that kind of changed the world?
Yeah, COVID. The court shut down.
And did that have an effect on slowing down things in the court systems?
It definitely stopped the court system. We continued to take some depositions, primarily law enforcement. It was at the scene early on, and then ultimately, when everything finally shut down, I'm not sure if it's May or April, when then we were sort of confined to our offices.
Did you, during the course of COVID, take the opportunity to sort of present the case to a mock jury to get an idea of how that jury might respond?
I did.
All right. And were the results very favorable for your client and not favorable for Alec?
They were.
Okay. Did you ultimately communicate that fact to the defense?
I did.
Had you come into possession of some social media videos that you believe would be very advantageous to proving your case and achieving a large recovery?
I did. And I shared those with John Tiller.
Let me get something marked real quick. Hold on. We'll show you what's been marked as Exhibit 401, State's Exhibit 401, and see if you recognize that document.
I do.
All right, and what is that document?
It's a screenshot of text messages between myself and Tabor Vox. Tabor is assisting me in the boat crash case.
All right, could you turn the screen to me real quick, please? All right, there's a reference here at the top. They damn sure aren't a placeholder or venue defendant, but they were hoping so. And then you respond about not walking, just taking $500K and not walking away from someone who's judgment proof. Is that correct?
That's right.
And I'm sure the court is aware, but just very quickly, what's being said there about Alec not being just a placeholder or venue defendant?
Well, so there are a couple of things going on here. In October of 20, I filed a motion to compel. Alex said he was broke. He doesn't have any money. He may be able to cobble together some amount of money, but he's broke. And I didn't believe it. So I filed a motion to compel, and about a week after I'd filed that motion to compel, Danny Henderson, who again was Alex's personal lawyer, came to my partner, said he couldn't believe that we were going after Alec personally. It was a line in the sand that I'd crossed, a number of things like that. So that's what this conversation is about. And, you know, by November, this is, I think, November of 2020, the Beach family, they want accountability. They want a pound of flesh, and whatever that's going to be, it's only going to be through a jury or through a substantial settlement.
All right, well, let me back up and we'll get to the motion to compel in a second. You mentioned that you had been told by the defense essentially that Alec had no money, correct?
He's broke.
Right. Did they say he could cobble together a certain amount?
Thought he could cobble together $1 million.
$1 million. And did you believe that that was accurate?
It couldn't have been.
All right, and why did you not believe that that was accurate?
Well, when you practice law, not necessarily with, meaning in the same case, but when you go to a roster meeting, if there were 50 cases on the roster in Hampton, Alec may have had 50 or 60 of those percent of those cases. And so they're actively being settled. I know that he's actively making money, and you just can't possibly be broke if you're making money, not the way he was making money. And then beyond that, I mean, my clients have known Alec and his family forever, and so their perspective is that there's generational wealth as well.
Did you, was $1 million going to be enough money from your client's perspective to settle this case?
It wasn't enough from my perspective.
Okay.
I can explain that if you want.
Yes, please.
Yeah. So one of the things that I didn't appreciate, that I came to appreciate by this point in time is that, and it may not make a whole lot of sense, but if I told a lawyer who does what I do that I'd settled the case, there's a lot of speculation because I've had cases with the firm and members of the firm are my friends, that somehow there's a fix on. I think for a long time Alec thought there was a fix on, that he was just a placeholder or a venue defendant.
Right.
And so if I told you I've settled the case, and then the next question would be, what did you settle it for? I said, well, I took the insurance company. If you knew what I know and what plaintiff's lawyers know, you'd think, well, there was a fix. The only reason I would take it is because there was a fix. I didn't see a substantial difference between that number and $1 million. And so I thought that if you told 10 lawyers who were knowledgeable about these kinds of matters, I took $1 million from Alex, who from everyone's perspective has lots of money, is making piles of money, they would think that it was a fix. So before we even get to what's a fair amount, what should you take, the analogy I use with my clients is kind of like that show Deal or No Deal. You may have the $1 million suitcase, or you may have a zero suitcase, but it's not until there's a significant enough offer that you could do worse that you should settle a case, any case. And so at $1 million, it just wasn't, there wasn't any risk to them that would prompt me to recommend them to take it.
Did you make any sort of formal or informal offer to them that involved the real property as well as any sort of payment plan?
When I was told that Alex was broke, I offered him a payment plan. Sometimes when you settle cases, medical malpractice cases, for instance, with the JUA, they will make payments. I offered for him to sign over Moselle and the beach house, open his books to see that he was broke, and then work out a payment plan on the balance.
So when you say, okay, you say he's broke, I don't believe that, show me the books to prove that, what was your response from Alex's defense?
Well, it was sort of stonewalling to begin with. I mean, ultimately, I got a formal response, which was an objection that prompted the motion to compel in October of 2020.
Let me get this marked real quick. I'll show you what's been marked as States 402. See if you recognize this document.
Yeah. So this is my motion to compel, which attaches Alex's responses to the interrogatories and requests for production.
All right. And when was this filed?
October 16th, 2020.
All right. All right, I'm going to put Exhibit B to this motion, your motion to compel, up on the screen and zoom it in a little bit. And in part, was this the objection to one of your supplemental interrogatories about what you're talking about opening the books?
Correct.
All right. And if you would, tell me what your interrogatory was asking for in number 1, please.
Well, in as broad terms as
Well, let's just read it real quick if we could, please.
all
Can
right.
you read that?
List all checking and or savings accounts, including credit union accounts, certificates of deposit, 401k accounts, SEP accounts, IRAs maintained by you individually and or jointly with any others, or any other accounts over which you had signature authority in any capacity, regardless of whether or not the account or accounts have been closed from February 2019 to present.
All right. And ultimately, what was the Alex defense's response to that, generally? You don't have to read that, but just tell me.
It was overly broad, unduly burdensome, and irrelevant.
Okay. And so ultimately, you filed a motion to compel, is that correct?
That's correct.
And the idea was, if you say you're broke, show me the books, and they had refused to with the response to this interrogatory, as well as others, is that correct?
Correct.
All right. To your knowledge, when information was being gathered by the defendant in this particular case. Let me ask you this. Who were his attorneys in the boat case, Alex attorneys?
So his personal attorney, as I've said, was Danny Henderson, who is also a partner or shareholder with PMPED. Progressive had hired John Tiller, and John Tiller was a lawyer out of Charleston. He was mainly involved. At one point, there was Amy Bauer, who was an associate working with John Tiller, and then Elliot Condon. Ultimately, I think Amy left in February of 21, and by then I think Elliot Condon had been hired and was assisting John Tiller.
Okay. And Mr. Henderson is a partner in PMPED that was also actively helping Alec or representing Alec in this case. Is that correct?
He was.
And he's the one that initially had brought you the insurance coverages for Alec to get you a chance to look at him and see what might be available, correct?
That's right.
As this motion to compel gets filed, what, if anything, happened with the sort of the communications between your side and the defense side as we moved into the months following the filing of that motion to compel? We already saw the one text. What else is going on as well?
Well, there's a lot of grumbling and sort of shock that I'm actually going to hold Alec personally responsible. Not so much with me, but like I mentioned, about a week after this, Danny Henderson contacts my partner. There were a number of times when Tabor Vox was contacted. And so nobody says anything directly to me in terms of that regard, but that's what's going on. It was said to them because they knew it would then be told to me.
When we look at the particular interrogatory right here that you have filed a motion to compel on, and what are you trying to get? What information are you trying to get with that interrogatory?
Well, you know, the way to, again, like in my example of the deal or no deal, I mean, what I'm trying to do is put pressure. He doesn't want me to have access to his accounts. At the time, I think it's because I'll see how much money he actually is making and how much he has. And so, you know, that's what I'm trying to do is put pressure on him to force him into a settlement. You don't want it disclosed? Here are the keys to the jail. You enter into an agreement and let's go settle the case.
In the event, though, he doesn't settle in response to this, what information are you trying to get?
Well, it's certainly not a number. It's certainly not Alec's estimation of what his net value is. I wanted the accounts because I knew that the only way that he could be broke is that money had been hidden. And so I was going to look for and trace or begin that process of doing that.
All right, and explain that to the court. When you say that you knew that if he was, quote, broke, in your estimation, money had been hidden, and so therefore you were going to look for and trace that information. What do you mean by that? Why did you think money had been hidden?
Well, there wasn't any way he could be broke. I mean, I know he's actively settling cases. Some cases, big cases, some cases, small cases, but they stack up lots of cases. He's handling a lot of cases. So there's just no possibility that he could be broke by anyone's definition.
If ultimately, and we'll talk more about this in a minute, if ultimately you'd been successful in getting a list of the defendant's accounts, what would have been your next step once received?
Subpoenas.
Of those accounts?
To those institutions, yes.
Were you already aware that defendant had an account at the Bank of America?
I knew that he had a personal account with Bank of America. I knew he had an account with Palmetto State Bank. So I'm looking for the balance of accounts in terms of institutions and where else he had.
But you didn't know how many accounts or what those balances were or anything like that?
No, I had no idea. I knew he had multiple business entities. He had different LLCs. So I imagine there could be any combination of accounts out there, and some which would not have even been in his name.
After the motion to compel is filed, I'm going to show you what's been marked as States 403 and see if you recognize that document.
Yes.
Tell me what that is.
Again, it's a screenshot of text messages between Tabor Vox and myself.
All right, let me put this up on the screen. All right, if you would, got this up on the screen. So can you tell me what's going on? And again, this is in April of 2021, is that correct?
It is.
And tell me what's going on with this conversation right here and how it relates to these issues.
Yeah, so in August of 20, I found out I had cancer. And by November, I knew how bad it was. And so in January, I went to, I had stage 4 cancer, and I went to Florida from the end of January till April the 15th on my first round of treatment. So I'd just come back. Shortly before I was diagnosed with cancer, John Tiller was also diagnosed with pancreatic cancer. And there's some degree of urgency between John Tiller and myself to finish this case. While I was in Florida, I think I failed to mention that Greg Parker's convenience store was also a defendant in the first case, but Greg Parker had done a number of things. And so before I leave, the issue is Greg Parker's moved to transfer venue to Beaufort County, which is where I had done the mock jury. The focus group was in Beaufort County. And while I'm in Florida, things have changed in terms of what he's done that have changed my perspective, because when I left, I intended to go to Beaufort. By the time I get back, I think I'm staying in Hampton. And so this conversation is, for the first time I've said that I'm going to leave the case in Hampton. But if I think that Alec has fixed the jury, that he's done anything to affect the outcome of the trial, that I'm going to sue Paul and Maggie the next day in Beaufort.
And was that communicated to the defense?
Absolutely.
In the course of your investigation of this case, had you taken depositions of some of the officers who were involved in the investigation?
We did.
And at some point, was that some issues arose that were communicated to the state grand jury?
You're the one that tells